Ready, start. Learned Second Additional Sessions Judge, Mandaleswar has found that there are sufficient grounds for proceeding against the accused and framed the charges against the accused as respondents 1 and 2 under Section 302 IPC read with Section 34 IPC. Full stop. Challenging the order of framing charges, respondents 1 and 2 have filed a revision petition before the High Court. Full stop. The court should apply the judicial mind and should give reasons in a concise manner for framing charges, and that the trial court has failed to apply its mind while framing charges, the High Court, while impugned order dated 25/2/2019, has quashed the charges against respondents 1 and 2 and discharged them. Full stop. Being aggrieved, the appellant complainant has preferred this appeal. Full stop. Mr. Bijan Kumar Ghosh, learned counsel appearing for the appellant, has submitted that there are circumstances like last seen together, close, semicolon, recovery of dead bodies, close, semicolon, not informing the family of the victim immediately upon discovery of dead body, close, semicolon, not informing the police, close, semicolon, recovery of other belongings of dead body including tractor, close, and such other circumstances connecting the accused respondents 1 and 2 with the death of Gopal Saran, and considering those circumstances, the learned Second Additional Sessions Judge satisfied himself that there are sufficient ground for framing charges against the accused. Full stop. The learned counsel submitted that when the trial judge was so satisfied that there are sufficient grounds for framing the charges against the accused, in exercise of its revisional jurisdiction, the High Court ought not to have interfered and quashed the charges framed by the trial court. Full stop. Framing of a charge is an exercise of jurisdiction by the trial court in terms of Section 228 of the Code, unless the accused is discharged under Section 227 of the Code. Full stop. Under both these provisions, the court is required to consider the record of the case, close, and documents submitted therewith, and after hearing the parties, may either discharge the accused or, where it appears to the court and in its opinion that there is ground for presuming that the accused has committed an offence, itself frame the charge. Full stop. Once the facts and ingredients of the section exists, then the court would be right in presuming that there is ground to proceed against the accused and frame the charge accordingly. Full stop. This presumption is not a presumption of law as such. Full stop. The satisfaction of the court in relation to the existence of constituents of an offence and the facts leading to that offence is a sine qua non for exercise of such jurisdiction. Full stop. It may even be weaker than a prima facie case. Full stop. There is a fine distinction between the language of sections 227 and 228 of the Code. Full stop. Section 227 is the expression of a definite opinion and judgment of the court, while Section 228 is tentative. Full stop. Thus, to say that at the stage of framing of charge, the court should form an opinion that the accused is certainly guilty of committing an offence, is an approach which is impermissible in terms of Section 228 of the Code. Full stop.